I successfully wrote a report for an insanity evaluation, and it was murder. It was more than one murder, in fact, and that was in the state of California. And it was successful, and it never went to trial, and that person went to the state hospital. Those cases are labor intensive, and you receive enormous amounts of evidence to review, and the reports are very lengthy. I would say early on in this case, this attorney, look, she's familiar with the role of forensic psychologist. I'm sure she's consulting with one. He doesn't appear to be a guy who needs to be evaluated for competency to stand trial, which is evaluating your mental health right now. Are you well enough to proceed? And then insanity is looking at their mental health at the time of the offense. So one of the questions I want to ask is, can there be a split verdict? So not guilty by reason of insanity for some charges and guilty for others.
I think it's usually one or done, because you can't be competent to commit one crime but incompetent to commit another. I mean, because right and wrong is right and wrong regardless of the case. It's like saying, well, you were too crazy to do the homicide, but you weren't too crazy for the firearm charge. So in my experience as an investigator, I've never seen that at all. It's either one or the other.
Like Eric said, you haven't seen one. I'm not going to say it's not possible to have what's called a split verdict in a case, where you might see a jury that the person, they meet the insanity standard with regard to one specific charge or one or more charge, but then maybe other charges they don't. So in New York, it looks like it's not a likely thing, but it could, at least I'm not a licensed attorney in New York. I can speak about California law only, but just generally, it looks like there's a mechanism that could allow that to happen. Again, that would involve a case where you have, multiple charges arising from the same kind of incident. And so that could arise where perhaps, even though insanity generally is the defense that's available to all types of crimes, both general intent crimes and specific intent crimes. And there is a difference, because in a specific intent crime, that requires a specific state of mind. Whereas in general intent, we're not concerned about the specific intent of the individual. The conduct that they engage in to commit the act is sufficient in a general intent crime. Murder is a specific intent crime. That's an example of a specific intent crime, whereas a crime like rape is not a specific intent crime. It's a general intent crime. So, you could have that happen where you have, say, multiple different charges, and some are general intent, some are specific intent, where a jury may find, okay, on this, we think the, insanity applies. But I think it's unlikely. It's like, I haven't personally ever seen it, in any illegal cases that I've been involved in through my years of investigating and that kind of stuff. I haven't seen that ever done, but I'm not saying it's not impossible.
It goes on to say that a defendant who believed what he or she was doing was morally right is not insane that the defendant knew that what he or she was doing violated societal standards or was against the law.
Yeah, that's why it's such a hard defense to overcome. We're talking about, people's understanding of what's right, what's wrong, and from a young age, most, people, we learn that stuff. We understand it, right? And that's why it's, I think, a really hard defense.